So, uh, this case takes place in 1992. We've jumped forward a large amount of time. Justice Kennedy writes the majority opinion for this court, and the decision's unanimous. And I wish I could say that with some asterisks because it's really not unanimous. There are so many concurrences in this case that the divisions are so clear, um, but the outcome of the case, at least on a sort of counting heads, is unanimous. Um, this case was scheduled for oral argument right after Justice Marshall made his retirement. Justice Thomas, who was appointed to replace him, took no part in the consideration of this case. So there are 8 justices remaining. Um, 4 of the justices agree with Kennedy, and the other 4 write a concurring opinion that you might just look at that concurring opinion as really a dissent. So there are 4 justices who join Kennedy's opinion. Those are Rehnquist, White, Souter, and Scalia. And then there are 4 justices who write separately. This case can be looked at as a really a compromise on the closing of the Brown era. That this is the case that sort of signals, at least in large part, the end of desegregation and integration efforts. Though, as referenced in Charlotte, they lasted until the year 2000. So there were still some hangers on during this time. So the facts in this case. This case concerns DeKalb County, a pretty major suburb of Atlanta, Georgia, who probably more of you now know where it is considering the election last year. It is the largest school system in Georgia and also one of the largest in the United States. The school district had been subject to the jurisdiction of the Northern District of Georgia Federal Court since 1969, when it was ordered to dismantle its de jure dual public school system. In 1986, the board filed for final resolution of the matter, which meant that the school district would no longer be in oversight. The district, hearing the matter, held that the school had achieved unitary status in 4 years. What unitary means is that desegregation and integration efforts were successful. And so the district court says that in 4 areas, you've met this standard, but you haven't met the standard in every area. And so the district officially relinquished oversight of 4 of those areas, but remained in control of these other areas where the school was not yet in compliance. So the local district court judge said, here are a battery of characteristics on which I want you to meet this unitary status. You've met it in 4 of this cadre of qualifications, but you haven't met it in all. So on these 4, I'm no longer going to review your actions, but in these other areas, you still need to meet compliance. The Court of Appeals for the 11th Circuit reversed that decision, basing its decision on the precedent set in Green, holding that a district court should retain full authority over a school system until it achieves unitary status. So the Court of Appeals says that no, the district judge can't rescind oversight in some areas and keep it in other. It's either an all yes or all no. And since the district court judge decided that it hadn't met full compliance, that the district court still has full authority over all of these areas. The Supreme Court, as I said, unanimously, quote unquote, reverses the decision of the Court of Appeals and remanded back to the Court of Appeals, holding that the district court judge is permitted, quote, to withdraw judicial supervision with respect to discrete categories in which the school district has achieved compliance with a court-ordered desegregation plan. So that is, the Supreme Court said that no longer, as the precedent set in Green states, these district court judges can give some autonomy to school districts in areas where compliance is met, and can keep compliance can keep oversight in other areas where compliance haven't been met. So basically, the majority sort of rubber stamps the decision, the policy decision of the local district court judge, in that they could keep some authority and also give some up. Justice Scalia writes separately. He agrees with the majority opinion, but he writes separately in a solo concurrence, who argued, and he argued that there's no reason to have any oversight anymore because no discrimination is no longer intentional. It's incidental. And so while Scalia joins Kennedy's majority opinion, he basically says that there should be no oversight at all. That there's no reason why these local district judges should be in command over any local school district, because if there is discrimination going on, if there is segregation going on, that's not a failure of these local officials. That the desegregation is it's no longer intentional. He is the only one out there on that island. For those who wrote a separate concurrence, Blackmun, Stevens, O'Connor, and Souter, Kennedy's decision goes too far. So it didn't go far enough for Scalia. It goes too far for Blackmun, Stevens, O'Connor, and Souter. In separate concurrences, because they wrote separately, these judges argue that lower courts should engage in a probing analysis of the district court's record before abandoning desegregation orders. So basically, we don't trust the district court judges alone to make this decision, because in some instances, the problems have been at the district judge level. And so while, yes, we agree with the majority that you can give up some autonomy and keep some in terms of review, we would say that you've still gone too far. And so we have this situation in which the method by which you prove that you've met desegregation efforts changes significantly. The precedent in Green says that school districts have to achieve authority status in all areas. In Freeman versus Pitts, they basically give up and say, well, if you can meet it in a few, you get autonomy in a few, and then we'll still review the others. It's a compromise decision. It's quote unquote unanimous, but it's not unanimous. The liberals and O'Connor would maintain more oversight. The conservatives and Souter would have everyone behave as a district judge in Georgia did, and Scalia would cut off any oversight whatsoever. So it's a compromised bookend to the end of the Brown era, an era which was, at least in terms of court jurisprudence, not as successful as Earl Warren and Brown 1 would have ultimately seen it play out. But there's no real difference in saying that school districts look very different in 1992 than they did in 1953. That school districts weren't systematically segregated, but in 1992 there still were, and today there still are, school systems which operated in a segregated fashion, a de facto segregated fashion. And the promises of Brown, the hopes of Brown, never truly are accomplished. And it's a battle that's still relevant today.